What are real estate disclosure laws? Real estate disclosure laws are statutes that govern how real estate agents must disclose information to buyers and sellers. Disclosure can include things like the condition of a property, any existing liens or pending legal matters affecting it, and any zoning restrictions in a specific area. What are some examples of real estate disclosure laws? Some examples of real estate disclosure laws include the California Residential Property Disclosure Act, the Florida Statutes, and the New York State Real Estate Property Laws. Why are real estate disclosure laws important? Some potential benefits of real estate disclosure laws include ensuring that buyers and sellers have the information they need to make informed decisions, protecting homeowners from unfair practices, and preventing fraud. Are real estate disclosure laws always followed? Yes, most real estate disclosure laws are generally adhered to. However, there are occasions when agents may choose not to disclose information for various reasons, example, because it is not relevant or would cause undue stress for the buyer or seller. Are there any laws to help protect potential buyers from the supernatural? In other words, are there any laws that require a seller to inform a potential buyer the property is possibly haunted or even if people have died at the property? With the increased interest in the paranormal topic these days, these are relevant questions potential real estate buyers might have. So, in general, yes, there are some statutes in place that would help protect buyers and sellers if they were interested in buying or selling a property that may be haunted or have other supernatural activity associated with it. Most states do not require home sellers to disclose paranormal activity to purchasers, according to a Zillow analysis. Just 4 states, New York, New Jersey, Massachusetts, and Minnesota, have real estate disclosure laws that include paranormal activity, according to a state-by-state analysis. If the seller creates and maintains a reputation for the home being haunted, and then takes unfair advantage of a buyer's ignorance of the home's ghostly reputation, courts in New York State can rescind the sale. To put it another way, if a seller has made public statements about their property having supernatural activity or ghosts, the buyer should be alerted to them. The buyer might take you to court if you fail to disclose those problems later. For example, if your home was included in a walking tour of haunted houses or if you applied to have a paranormal television program filmed there. Nonetheless, just having a notion that something odd occurred there or knowing that someone died in the house before doesn't compel you to share any suspected weird activity. If a seller in New Jersey is questioned about supernatural activity, they must accurately inform the buyer. Misrepresenting the facts could result in a lawsuit. The supernatural is covered in statutes in Minnesota and Massachusetts, but it isn't required to be reported. In conclusion, buyers should be aware that your dream house may be haunted, and the fact of the matter is, in most states sellers do not have to inform you about it. In general, disclosure laws protect buyers and sellers by ensuring that all relevant information is disclosed to potential customers before they make an important purchase. In some states, if there are suspected supernatural activities associated with a property, the seller has an obligation to disclose this information to buyers so they can decide for themselves whether or not it's worth buying the house.